It's common these days for spouses to have subsequent relationships and bring with them children from their prior relationships. This is called a blended family situation. Now, estate planning can be a complicated process in and of itself. However, when you have a blended family, there's additional factors that you may want to take into consideration to make sure that not only your children, but your spouse's children are looked after. The mirror will and the mutual will are often used in estate planning for blended families. Although people will use the names interchangeably in everyday discussion, there are important distinctions between the two. Now, depending on your particular situation, that will govern which one you may want to use. Mirror wills are frequently used and fairly straightforward in nature. Usually what will happen is both spouses will create wills with identical provisions in them. Usually they will leave everything to each other, and if that spouse predeceases them, the remainder will go evenly to their children. In the mirror will situation, the surviving spouse has full control and ownership over the deceased spouse's property and assets. It becomes theirs and theirs alone. There's no restriction on what they can do with it. Furthermore, they aren't restricted from changing their own will in any way. This can be a positive point in that they may survive their spouse for many years after. There may be many changes in their life, further spouses, further children, and this permits them to adjust their will accordingly without any restriction. The problem with mirror wills is that when they were made, everyone got along and had the best of intentions. However, after one of the spouses passes, it may be that the relationship between the surviving spouse and the stepchildren breaks down. Nothing stops that surviving spouse from revising their will and disinheriting those stepchildren altogether. In British Columbia, stepchildren don't have standing to bring an application to vary the will of the surviving step-parent. Therefore, the intentions of the deceased spouse will not be carried out, and their biological children could get nothing. An alternative to the mirror will is the mutual will. Now, these are similar to mirror wills in that the terms of the will effectively mirror each other. However, the key difference is that under a mutual will, the spouses agree that they will not change their wills without the express agreement of the other. This agreement continues after the spouse's death. These are frequently used in blended family situations as they give some additional assurance that your children from your prior relationship will be looked after once you pass away. For a mutual will to be binding, there must be clear and unequivocal evidence that the parties intended to enter into a mutual will as opposed to simply mirror wills. This means that the evidence must show that the parties effectively wanted to enter into a contract with each other that they would not change or revoke their wills. Now, the drawback of a mutual will is its restrictive nature. Again, if a surviving spouse survives for several years, they may have significant changes in their life. And to update and adjust their estate planning, there will be additional factors they'll have to take into account so that they honor the terms of that mutual will. In summary, yes, blended family scenarios do bring additional considerations to estate planning, which may not be apparent at first. It's important to put careful consideration into your estate planning. Our Wills and Estates team can assist you to make sure that your beneficiaries are well looked after once you are gone.